Thanks so much for joining us then, everyone. And we're really delighted to have you all here and to have Gavin from the Centre for Environmental Justice. He's an environmental lawyer, a barrister with community law mediation. And only in recent years, they've had the Centre for Environmental Justice. So yeah, they offer these workshops, and we're just delighted that they're able to give us their time. And this is going to be just a broad overview of environmental justice and rights. But if there is interest within the group to dive a little deeper, Gavin has said between himself and Maya, who's the community outreach officer with them, that they might be able to get back in touch with us to if there's a desire for further exploration of this area. So I'll hand you over to Gavin. Thanks so much, Gavin, and welcome.
As I said there, my name is Gavin Elliot. I'm with the Centre for Environmental Justice at Community Law Mediation. And this is just a kind of a brief overview of environmental justice, a little bit of an overview of what we do, and then maybe a little bit more specificity on the Aarhus Convention and how the Aarhus Convention is useful for access to information, how you can use it, and how we can help. So if there's any questions, I'm more than happy to take them at the end, or just interrupt me as we go along. That's absolutely fine as well. So as I said, the Community Law Mediation, we're a free and independent legal advice centre, a little bit like FLAC. We have been around since 1975. And in 2021, we established the Centre for Environmental Justice, which works on environmental justice, strategic climate litigation, and more generally does a little bit of policy work around climate and climate justice. The centre being established in 2021, I suppose, in the middle of COVID, in the middle of lockdowns, probably took a little bit of time to get off the ground, but we're now up and running, and we're growing as well. So we're taking our first cases in the Irish High Court, and our first cases on a European level as well. So we're gearing up to take more litigation as we go on. So just then a little bit about environmental justice generally. The centre is predicated on the understanding that communities who experience disadvantage or marginalised communities are more vulnerable to the effects of climate change, things like pollution, energy poverty, and other environmental harms, often because they live in areas with high levels of pollution, less access to green space, less access to the ability to remediate the worst effects of climate change. Often because accommodation can be very poor. Things like energy efficiency schemes are often designed with upfront payments, and retrofitting measures are similarly often designed that way. So marginalized or disadvantaged communities are often excluded from access to anything that would blunt the worst effects of climate change. Environmental justice seeks to protect the most vulnerable in society while and protect them from the worst impact of environmental harms, but also to ensure that any transition to a low carbon society is done in a fair way, which takes account of the particular circumstances of marginalized and disadvantaged communities. So apologies for the small type there, but that's just a list of the sorts of environmental harms, environmental degradation that we deal with in the centre. So the way the centre operates is, or the way that I think of it, is that we do really two things. The first is we run weekly or fortnightly clinics where individuals who have issues around environmental law questions can come to the clinics and get free legal advice, and depending on our resources, we may be able to advocate on their behalf, and we may be able to offer representation to them as well, again, resource dependent. The other thing we do is more strategic, high level climate litigation, where we're looking to challenge legislation or challenge the sort of things like the climate action plans or the adaptation plans, to ensure that they are compliant with human rights obligations, but also compliant internally with themselves, so that the government says what the government says they'll do, they're actually doing. So the things that come through the clinics are things like illegal dumping, running of private waste, homes at risk of flooding, housing conditions, access to green space, noise, light pollution, pollution of fresh water, and things like infrastructure, dereliction, biodiversity loss, planning issues, and difficulty accessing information, environmental issues. One of the challenges that we've faced, I think, and that we're very aware of in terms of running our clinics is that there are an awful lot of people out there with environmental issues, people out there with environmental law queries and with concerns. But when people, general public, sometimes think of the environment, they think of environment, the big E, they think of climate. They don't necessarily think of how you know, that litter in their area or risk of flooding or illegal dumping can be environmental matters, which of course they are. So it's kind of bridging that gap, the knowledge gap is sometimes what the communications side of the house in CLM deals with that quite a bit. So just to give, I suppose, an example of how important it can be for the sort of environmental justice litigation can be. I think you're probably all going to be aware of the Klima Senioren case, the Swiss seniors case, where the Grand Chamber of the European Court of Human Rights recently delivered its judgment, which was a very significant judgment. That was a case that was brought by a group in Switzerland of older ladies who were making the case that their human rights were impacted by climate change and by the reluctance of the Swiss government to take action on climate change. And in a very significant judgment, the court held that their rights had been violated. In particular, Article 8 had been violated, Article 8 of the European Convention on Human Rights. So it's one of the first cases to explicitly make that connection between human rights and climate change. And it's a growing area of litigation. It's going to continue both in international courts and domestically. So I think the next decade or so, we'll see a huge increase in the amount of climate change litigation and human rights-based climate litigation. If we just move on then. So just then 2 examples to demonstrate the types of cases that we take. The first was a challenge to the construction of a road in Sligo on the basis of failure to comply with the Habitats Directive, and in particular failure to comply with obligations under the Habitats Directive to ensure that when an environmental impact assessment is done, that future developments between the time that the impact assessment is done and the time that construction begins are taken into account. And that was a case that we took where a local residents group had concerns about the impact of road development on habitat loss in their area. Particularly, it was a river area, and there were concerns about swan habitats, there were concerns about bat habitats, there were concerns about lots of different and lots of local amenities in terms of access to green space and that sort of thing. And that was a judicial review of a decision by Umbor Planola, which was settled last year and to the satisfaction of everybody, however, the satisfaction of our clients, possibly less to the satisfaction of Sligo County Council. But it just mentioned as an example of the types of cases that come to us, but the types of cases that also are, that we're dealing with from an environmental justice point of view. On the other side of the coin, then, a case that we're currently taking is a legal challenge to the Irish government over its failure to properly quantify the emissions savings in CAP23, Climate Action Plan 2023, and the Annex of Actions. So that is quite a complex piece of strategic litigation on whether the government has breached its obligations under the Climate Action and Low Carbon Development Act 2015. And that's ongoing at the moment. But again, it just represents the other side of the coin in terms of the two types of environmental law matters that we tend to deal with. Moving on then to, I suppose, the Aarhus Convention and how that can be used, and to the meat of what we're talking about today. The Aarhus Convention is a piece of a treaty, I suppose you could call it, that was signed in 1998 in Aarhus, hence the name. It's the full title is there on the screen. It's the Convention on Access to Information, Public Participation, Decision-Making, and Access to Justice, Environmental Matters. So you can see why it's sometimes just called the Aarhus Convention. But it's very important. It's important for a couple of reasons, and it's becoming, I think, more important as time goes on. It is supposed to look at the relationship between people and government in relation to environmental matters and provide a bridge then between environmental protection and human rights. So the quote there from Kofi Annan is, I think, probably quite accurate and was said a long time ago, so probably will become, as time goes on, it's being proved to be more accurate. But that the most impressive elaboration of Principle 10 of the Rio Declaration, and as such, is the most ambitious venture in environmental democracy so far undertaken under the auspices of the United Nations. And just so that you have it there, the convention, the Aarhus Convention, builds on what Kofi Annan was talking about there, which is the Principle 10 of the Rio Declaration, which was part of the Earth Summit in Rio de Janeiro in 1992, where it talked about environmental issues being handled best by participation of citizens. That idea first elaborated there in the Rio Declaration, that access to justice, access to information, and the right to participate being vital components of environmental democracy and participation of individuals in the environmental protection process. The Aarhus Convention is incorporated into Irish law in a million different ways. Well, maybe not a million, but certainly more than 60 different pieces of legislation. Those are just some of them as an example. So the way to think of it, I suppose, is that this treaty imposes obligations on Ireland that it has signed up to and voluntarily undertaken. The treaty isn't incorporated into Irish law in one piece of legislation, so there's no Aarhus Convention Act or anything like that, but it does come into lots of different pieces of legislation, and pieces of legislation that are currently being drafted or will be drafted in the future have to take account of the obligations in the convention. So things like the planning bill, which is currently going through the Oireachtas, a lot of the discussion at the committee stage for that particular piece of legislation spoke about the Aarhus Convention and the obligations thereunder, and whether or not the new planning laws were compliant with Aarhus Convention rights and that sort of thing. So as you can see there, there's a few pieces of statutory instruments that regulations on access to environmental information, for example, or industrial emissions regulations. All of those are things where the Aarhus Convention has informed how those regulations are drafted and what they actually say. So the convention itself then is a recognition of individual rights and individual citizen rights. It contains sort of procedural rights to information, participation, and justice. It explicitly takes into account the rights of present and importantly future generations to live in an environment adequate to health and well-being, which is in Article 1 of the Convention. And I suppose as well, importantly, it takes a very wide definition of the terms that are used in it. So I think that sometimes people are quite pleasantly surprised when they actually read the convention itself, because it's not necessarily framed in legalese, it's not necessarily framed in difficult language, and it's not framed in terms of exclusions. So the public, when it talks about the public, it talks about any natural or legal person or any informal group, so that's a very wide definition. public authorities or all sectors, all levels of government, excluding the courts, but that's would be quite natural, I suppose. Environmental information is quite broadly defined. The anti-harassment, non-discrimination provisions in the convention can be are available to everyone, irrespective of citizenship, nationality, domicile, etc. So those very broad definitions are a part of the convention, and there's an intention that it be interpreted very broadly. There's three main pillars, I suppose: access to information, access to public participation, and then access to justice. We're going to concentrate, I suppose, maybe on the first of those, access to information, but also then maybe just skim through the other two very quickly. And particularly access to justice kind of relates very closely to the first two. So access to information, the first pillar of the convention, there's a way of thinking about this which I think is very helpful, which is that access to information can either be reactive or, you know, in terms of people having to react to something, or it can be an obligation that's on the state where they have to be sort of proactive about it. So that sort of proactive or reactive obligations that are placed on the state. So the reactive ones, which I think probably people will be most familiar with, is the information requests under Article 4 of the Convention. So any person has access to environmental information, a very broad definition of what environmental information is. There's a time limit imposed, so 1 month plus another month. Charges must be reasonable, and there's a finite set of exemptions. So we'll look at all of those, but essentially this gives individuals, organizations, the right to make what are called, in an Irish context, AIE requests, access to information on the environment. And information can be requested from any public authority, which is any body or organization that has a role in public administration, obviously that possesses the information that you're looking for. Includes things like government departments, local authorities, semi-state agencies, state agencies, regulatory bodies, the president, certain other offices, bodies performing administrative functions, like the ESB in certain circumstances, private entities such as wind farm operators as well. So there's a very broad definition of what public authority is in terms of AIE requests. And there's a time limit as well. So if you are sending an AIE request, the public body must respond within 1 month, unless they say it's particularly complex, where they can extend that for another month. But they must communicate with you at all stages through that if they're extending it. And just to give you an example of what an AIE request actually looks like, that's the template that we use. So as you can see, it's a very, very straightforward thing. Sending in a request for environmental information is very straightforward. You literally cut and paste what we have there, insert the address at the top, insert what you want, insert your email address, and then you send it off. It's free. No, unless this body comes back and suggests that they wish to charge, but even then the maximum fee is €100. So there's a few sort of like tips and tricks as how to get better responses from the state bodies that you're sending them to. But basically, there's as long as you make it clear that what you're doing is you're sending in an AIE request and you list the information, they have an obligation then to respond. It's a little bit like a data protection request, if you think of it that way. There is no way you can sneak out of it by saying we didn't really understand it was an AIE request, etc. You know, if it can be interpreted as such, then it has to be interpreted as such by the body that receives it. Some of these requests can be refused. They can be refused on the basis of confidentiality, that you know, adversely affect the interest of the person who requested information, or the protection of the environment, or the confidentiality of legal proceedings, etc. I mean, what we see quite often is the refusal of AIE requests for reasons that are a little bit spurious. So sometimes what we have experienced and some of our clients have experienced is an AIE request is sent in. The person then gets a phone call, is asked to withdraw that on the basis that it's going to be refused anyway. They withdraw it. So the state body doesn't have an obligation that actually sort of to refuse it. They're just asking you to refuse it. So that's just something to be aware of in terms of making them. But you can see there as well, there are some discretionary grounds in which the request can be refused. If it relates to international relations, defense, etc. If it's unreasonable, having regard to the range of the information sought, that sort of thing. But those exceptions are all to be interpreted restrictively. And interestingly, they do not apply if the information concerns emissions targets or emissions data. And you may still be entitled to partial release, so you should still be entitled to some information, even if some of the information isn't, is being refused. There has to be an internal appeals mechanism, and then there's an appeal to the Office of the Information Commissioner, or the Commissioner for Environmental Information, rather. And you must appeal within a certain time frame, but there's that appeal. And then if you're still not satisfied, there's a further appeal is possible to the High Court if you're still not getting the information that you're entitled to. The other way is sort of more proactive obligations that are on the state in terms of access to information. That first pillar is that there's a positive obligation of the state to collect, manage, disseminate information on the environment. There must be transparency and accessibility of information systems. There must be, if insofar as possible, immediate dissemination of information if there's a threat to health or the environment. Laws, strategies, programs, action plans, all of those things must be disseminated. Pollutant release and transfer registers must be, or specifically mentioned as things that should be disseminated widely, and these things must be done, if at all possible, through the internet. But again, while there are things that are mentioned within the convention, that proactive obligation to disseminate information is quite broad and it's quite general. So it is a thing that you can use to lobby for information to be made available where it isn't currently available. So because there is that obligation, that general background obligation created by the convention, that state bodies should be making information available. They should be doing it in a way that's transparent, as quick as possible, as real time as possible, and in a way that's as accessible as possible as well. So if that isn't happening, then that's a right that you can, or an obligation rather, on the state that you can kind of say that they aren't fulfilling. Kind of related to that a little bit is the obligation then in Pillar 2. So Pillar 2 talks about public participation, and it gives a general right for the public to be consulted where environmental matters or potential environmental degradation or harm is anticipated or might be reasonably expected. So that, for example, public participation is required for the development of legal acts relating to the environment. That's under Article 8 of the Convention. The public has a right to participate in decision-making regarding environmental matters. Public authorities should enable the public to comment on, for example, proposals that might affect the environment. The outcome of public participation should be taken into consideration in decision-making. So again, I mean, one of the things that we see a lot is planning matters where people come to us and there may be a residents group or a local group who haven't been properly consulted on issues. And one of the pieces of advice we would often give is that under that second pillar of the Aarhus Convention, you're entitled to be consulted. Your public participation is required. And it's certainly also the case that, it's certainly open to groups to say that public participation wasn't good enough. It wasn't expansive enough. It didn't go far enough. That is often the case with big infrastructure projects where, they might send leaflets out in a half-mile area radius. It's certainly possible for people further afield to say, no, we're impacted too, and we have a right to be to participate in these decision-making processes and to be consulted. So what obligations have the government then to ensure public participation? informing the public of matters that they can participate in, providing guidelines for how the public should be involved in decision making, informing the public of decisions that are made, domestic legislation that has been used to transpose the directive into Irish law. For example, in planning law, where there's that public participation aspect in terms of appealing decisions to Bord Pleanála or in an earlier stage in the local authority. But those are things where that public participation aspect is kind of baked into the legislation. But again, it's entirely open to members of the public, to rights holders, citizens and others, to say that actually that hasn't gone far enough and the public participation isn't good enough, and that there is this obligation under the convention that they have the right to participate. And again, you know, if there's consultations on things where at a local authority or state level, it's entirely possible to say, no, actually, you can't, it's not a box ticking exercise. You must do this properly. This was done badly, or this was, you know, these questions that were asked in this public consultation process were biased or something like that. So, you know, those general purpose rights exist in the background and can be used. And then just finally, the access to justice thing, which is pillar 3, something that's very important in terms of those rights, and particularly what I spoke about earlier with the planning bill and how that's vindicating the rights under the Aarhus Convention, where one of the things that the committee talked about a lot was whether or not restricting the right to judicial review was coherent with the Aarhus Convention, because that's one of the things that the new planning bill seeks to do, which is exclude some groups of people from taking judicial reviews, and whether or not that's can be coherent with our international obligations and with our treaty obligations under the convention. And I think a lot of lawyers would say that it isn't, and that actually they're likely to be challenged and actually likely to be struck down by the courts on the basis of that people won't have sufficient access to justice in environmental matters as required by the convention. So that is just a very quick whistle-stop tour. And there's our contact details should you want to contact us. And we run our clinics weekly or fortnightly, depending on demand. And if any of you have any particular environmental issues, or you know anybody who does, then direct them towards us. But other than that, I'll hand back to Daddy.
Thanks a million, Gavin. That's really, really interesting to hear the scope, the reach, the range of work that you're covering. I wonder, are there any questions there from anyone, guys? Feel free to unmute and jump in, or you can put your questions in the Q&A in the app if anyone wants to do it that way either. Maybe just while we're waiting, Gavin, you mentioned there were tricks and tips to get better responses to the AIE, the access for information to the environment. What kind of tips would they be for how to ask those?
So I think one thing that people sometimes get wrong is that with AIE and with freedom of information is the same. All you're entitled to have access to is to information that already exists, or to documents that already exist. So sometimes people ask for documents to be created, or ask for information to be compiled, and sometimes people are refused on that basis. The other thing, I suppose, is to keep the request as specific as possible, so that it's not refused for being too general, and to keep it to kind of have a think about what sort of documents might exist, which will give you the information that you want, and then to target the particular organizations that might have those, and to also think about what sorts of organizations might have information. So you might be looking for information on a wind farm development or something, or but there might be a dozen or more different organizations that would have some information about that. So my advice is to, it's the cost of an email, really. So you might as well send out 6 as send out 1 request, and then just make sure that you're kind of like have a scattergun approach, but be very precise with the actual information that you're requesting.
Perfect. That's really helpful. Thanks, Gavin. And there's a question there from Sam. Go ahead, Sam.
Thanks so much, Dolly, for organizing, and thanks, Gavin. That was actually really interesting.
No
I
worries.
had a quick question, kind of circling back to what you were kind of discussing at the start and like your kind of scope of work. And I was interested, is there any kind of cases that you see kind of coming in into the clinics? And obviously, like it's an environmental problem, but it's just really hard for you guys to kind of litigate it or to solve. Is there anything that comes in, you're like, oh no, not again?
I suppose one of the things that it's quite difficult is noise pollution. Noise pollution is quite difficult because there's very little in the way of obligations on anybody to do anything about it. So often when people come to the clinics, what they're sort of looking for is a little bit of a steer on, um, who in the state apparatus is responsible for this issue and how can I get them to do it? Is there any way, do I have to force them to do it legally? Often it's the local authority failing in their obligations, or it's the, state failure, or it could be, a state body that has failed, and you kind of are, there will be obligations there, but they're not being met. Whereas with, I think, noise pollution in particular, it's really quite difficult because there isn't really an awful lot that can be done. So often you're kind of you're not really in a position to kind of tell anybody, well, write to this person, inform them that they have an obligation under section whatever, and see what they say. Where with noise pollution, unless you're near a road, sometimes it can be quite difficult to kind of get any action on that. But yeah, there's so that's one thing that springs to mind. Another thing is it can be sometimes with when it comes to rivers, it can be quite frustrating because you'll get every agency in the country saying that it's somebody else's responsibility. If the local river is polluted, there'll be 10 different agencies denying that it's their responsibility, but it's definitely somebody else's job to clean that up. So again, sometimes you're just giving the advice you're giving is be prepared to be told by everybody that it's not their job. So yeah, those are the two that spring to mind.
That's really interesting. Thanks, Gavin, for that one. And just I guess I'm thinking as well in terms of um the health angle is maybe a big one in terms of like uh the framing of this as an approach to go ahead, and obviously the human rights, we're seeing more of that. Hopefully we will be in the as the based on the European ruling in the European Courts of Human Rights. Are there any, what other kind of framings or approaches would you typically have more success? Like was going under the Habitats Directive, or those things, are they any less or more successful than the health or human rights approach?
Yeah, I mean, I suppose the health thing is something that's quite I suppose it has a sort of immediate impact on people. That can be quite a big thing. Particularly, we've done a lot around air quality, and air quality and the impact on health is obviously quite significant, particularly children's health. So that does tend to kind of get a lot of people quite angry quite quickly if they feel that their children's health is being impacted by bad air quality, and there's an obligation in the state to actually do something which they're not doing. So so that's kind of an interesting framing. I mean, I suppose that the one of the things that you see very clearly is it's sometimes having to kind of push back against what is a government uh, position that is sometimes put forward by them, which is that if you're objecting, for example, to a development or on grounds of habitat loss, then you're anti-housing, you're anti-infrastructure, you're opposing your NIMBYism, et cetera, et cetera. And honestly, I think, I mean, the vast majority of people who've come to this clinic over the last year and a half or 2 years, I'd say I could count on one hand the amount the people that have come to the clinic who are anything other than genuinely concerned about their local area. They are people who are, do deeply care about, local wildlife. They care about the natural, their surroundings and the natural environment, and they want to protect it, and they want to be involved in making those decisions. But yeah, sometimes they're, they come to you and they kind of have to constantly reinforce the fact that they're not opposed to housing, they're not opposed to, you know,
Yeah.
and you're kind of saying, no, I know, you know, but that's probably what they're being told by developers or by the government or by that sort of, you know, that attitude that sometimes you get in the press as well, where if
Yeah.
you know, this ring road is being held up just because of a snail and that sort of thing.
I know, and the optics of that, it's so important to kind of to make sure that you're not being misrepresented and to have to try and get clear communications about what your motives really are. And that's very interesting.
And just finally to say that the template for the AIE request is on our website. If there's a guide to the Aarhus Convention on our website, and it's an appendix at the very end. So if you want to copy and paste that at any stage, just go there and do that.
Brilliant. And the website, it's on the community law mediation.
Community law and mediation.ie. It's massively fun.
Great. Thanks so much, Gavin, and thanks everyone else for joining us. Cheers. Have a nice evening.
Thanks, Sam. Bye-bye.
Cheers. Take care. So on.